because there's really no dispute that these were intentional acts, that somehow the only issue remaining for trial is the reasonableness of the defendant's actions. That may very well be where we're at the end of the trial, but at the beginning of the trial, I have a burden of proof. There are claims against the defendant that go to his state of mind in terms of intent or recklessness, and it's my burden to prove that. At that time in the case, I won't have any testimony from the defendant. I don't know if he's going to testify or not. He doesn't have to. He has the right to remain silent. So I certainly can't presume what evidence may or may not come in the defense case. This is an unusual homicide case in the sense that it is not a whodunit. This is not a question of did the defendant kill anyone. The question is what was his state of mind and whether or not his actions were reasonable or not, and whether or not they go to intent or recklessness or some other mens rea. That is the mental state that the state needs to prove. We don't convict people without the requisite mens rea. So his state of mind is perhaps the most critical issue in this case. The motions that we filed, both this one and the other acts motion that we'll get to in a moment, illuminate the defendant's state of mind, both on the night in question and also on these preceding events of June 1st and August 10th, which is the date of the other motion, or the events of the other motion. And I believe that these motions help the jury to understand the defendant's state of mind. And I think that that is a relevant element, both in terms of the criminal charges here and also under State v. Sullivan, in terms of intent, motive, knowledge, absence of mistake, etc. The first motion that you've discussed, Judge, has two prongs to it. One is with regard to that June 1st fight. That is a fight which has been captured on video. It is an incident in which it's my understanding that the defendant's sister got into a physical altercation with another female. This was essentially a one-on-one fight, somewhat of a consensual fight, both of them interested in assaulting one another. But in the midst of that, Mr. Rittenhouse intervenes and begins to add on to what his sister is doing to this other female by assaulting that second female. And I think that that goes to the defendant's state of mind in this case because it shows that his understanding of self-defense, his understanding of the need for self-defense is a certain way, and I think it's an improper and unjustified use of it. I also think it goes to what I will posit will be a strong theory of the state's case here, which is the defendant is essentially a teenage vigilante involving himself in things that don't concern him. And we have a common theme here, both with regard to this incident and the August 10th incident that's the subject of our second other acts motion. The defendant throwing himself into situations that don't concern him, that he has no complete knowledge of, that no one asked him to be involved in, and using force or threatening to use force in an unjustified, illegal, unwarranted manner. So I think with regard to this other acts motion, that June 1st incident illuminates the truth for the jury. It illuminates the defendant's state of mind. And the jury is going to have to consider that state of mind when it makes its determination here in this case. The second part of that other acts motion is with regard to the incident after a court appearance in January, where the defendant goes to a bar in Racine and is serenaded by members of the Proud Boys. Now, we have since learned that those individuals that were serenading the defendant consist of the highest echelon of the Wisconsin Proud Boys chapter, including their leader, their current sergeant-at-arms, their former sergeant-at-arms, and other high-ranking members of that organization. This was not a random crossing of paths here in a random bar at a random time where they just happen upon one another. This was something that was coordinated. This is something where Mr. Rittenhouse intended to be there. These other individuals intended to be there. And the Proud Boys organization is relevant to this case because we have to put the incident of August 25th in context. This was not a festival in the park where somebody suddenly pulled out a gun and started randomly shooting. Most everyone that was there on the streets of Kenosha on August 25th was there because of their beliefs, one way or another, with regard to the shooting of Jacob Blake. And I don't need to argue one side or the other. The court does not need to make a determination one side or the other. But we can't ignore the fact that people were drawn to the streets of Kenosha that night because of a response to the shooting of Jacob Blake. There were some out there that believed that that shooting was justified. Some felt it was unjustified. There were other chaos tourists like the defendant who were drawn like a moth to the flame to our community. We've seen folks that have committed crimes under the cover of that chaos, burglaries and looting and arson. The defendant wasn't one of those people, but this was the type of person that was drawn to our community. The defendant, I believe, was drawn to this incident because of his beliefs, which are consistent with those of the Proud Boys. And I believe that those beliefs include a desire to use violence to support that philosophy. The Proud Boys are a well-known national organization that takes pride in using violence to achieve their means, that takes pride in showing up at rallies and protests by what they consider to be their opposition, which can be loosely considered to be Black Lives Matter or Antifa or whatever you want to call them, and using violence to disrupt those protests. The defendant came to our community. He's not a resident. He's underage. He's out after curfew. He's armed with an illegal weapon. Why? That is the question. His state of mind, his intent that night, is a crucial issue in this case. The defense will no doubt try and portray the defendant as an altruistic, young, idealistic individual who was here to try and help our community, protect a business, clean up graffiti, use his medical supplies to help people in need. They will try and show his state of mind as being a positive, helping one. The state is entitled to introduce evidence that further illuminates his state of mind for the jury. And the jury will ultimately make the decision as to his intent, his motives, his state of mind, what he personally believed at the time of these shootings, and they will introduce their reasonable impressions as our community members as to what a reasonable person would do in those circumstances. So those are the questions the jury is going to be asked. I believe a trial is about the truth. I believe that these issues go to the truth of the matter. The jury can be advised as to how to consider the weight of this evidence. The jury can make its determination as to the weight and the relevance, the importance or the pertinence of this in terms of whether it's really a true description of the defendant's state of mind or whether the other side, portraying him in a different light, is the true portrait of his state of mind. But I believe the state is entitled to introduce these two pieces of evidence as part of our first other acts motion because it goes directly to these issues. Looking at the Sullivan factors, these are being sought to be admitted for a proper purpose. They are relevant to the issues at the trial, and they are not unduly prejudicial. They are close in time. They are directly relevant to the factors in this case. The court can give a limiting instruction as to the use of this evidence, which will also help to mitigate any undue prejudice here. But again, these are the defendant's own actions. He's responsible for his actions. What he did on June 1st, what he did at the bar in January in Racine, and of course, what happened on August 25th here. So for all those reasons, Your Honor, I believe that the court should grant our first other acts motion and allow the state to introduce these pieces of evidence as part of our case in chief. Thank you.
Thank you, Mr. Richards. Mr. Schroeder.
Judge, I'm going to address it if I could. Thanks. So as it relates to the first other acts on June 1st, so the state is asking you or inferring that they're able to ascertain Mr. Rittenhouse's state of mind 2.5 months prior to the incident. So his state of mind on June 1st and his actions on June 1st somehow play a role in his state of mind on August 25th. This is, as an officer of the court, this is what I'm telling you. Mr. Rittenhouse it will not be debated that this action was intentional. It will not be debated that the action was intentional, and he will raise the issue regarding self-defense. When we're looking at the purpose of other acts, intent is one purpose, and it's a proper purpose. However, intent is normally admitted if it undermines an innocent explanation for the person's behavior. That is not happening here. there is no innocent explanation. There's an explanation, but he fired the firearm intentionally. As it relates to motive, if they are trying to establish that he had some motive 2.5 months before, teenagers getting into a fist fight, does that make it more or less probable? Is it a fact of consequence that he was in a fight 2.5 months earlier that he did not act in self-defense in this case? Does that make that more or less probable? The answer is it does not. It doesn't have anything to do with whether or not it makes it more or less probable that he acted in self-defense. The entirety of this is captured on video. The only issue in this case is going to be the reasonableness of those actions as they're determined subjectively and then objectively from a reasonable person in his position. So they describe him as being somebody who comes to Kenosha looking for trouble, even though they don't mention he works in Kenosha. He works in Pleasant Prairie, and that his father lives in Kenosha. And I would submit to you that when you look at the similarities, if we're really going to do a Sullivan analysis, the biggest thing in Sullivan that was different really was the manner and form in which one was a verbal argument, one was an assault. And if we have reached the position where teenagers getting into fistfights makes it more probable that a teenager then used a firearm in self-defense, when we have the self-defense on tape, we have the case on tape, I would submit to you it adds nothing to that determination as to whether or not his actions were or were not in self-defense and whether they were or were not reasonable under the circumstances. So where I believe it fails, if you believe it's the proper purpose, it adds nothing to the case as it relates to his state of mind 2.5 months later. And certainly because this isn't a whodunit, and it wasn't an accident, it is an intentional act with an affirmative defense attached to it. And I don't think under those circumstances, this particular instance has any relevance to that, all right? As it relates to the Proud Boys, I mentioned this in the brief, and Mr. Binger has ignored it.
Mr. Binger, what?
Mr. Binger has ignored it. For this to be considered by you, there must be evidence by a preponderance that on August 25th, 2020, Kyle Rittenhouse was either a member of the Proud Boys or had loyalties to that group. It is no different than you would make a determination if there was, for example, somebody wanted to introduce evidence of a gang membership. I'm telling you as an officer of the court, we have downloaded Mr. Rittenhouse's cellular phone. We have had an expert review that phone. That expert has done an analysis to try to determine if there is anything on that phone related to Proud Boys, militia, white nationalists, Boogaloo Boys, KKK, 3%ers, any type of hate group that you might consider. And the finding was the extraction does not establish that the user belonged to or even had any interest in any malicious-style organizations. Mr. Binger has provided you no information whatsoever that on the day in question, August 25th, that Kyle Rittenhouse had any affiliation with that group at all. He's asking that you take and allow evidence to be admitted over 4 months later about a photograph without any information that anything related to this case involved the Proud Boys. There has been nothing. And I have cited for this court cases in my brief related to for example, gang memberships. And in every one of those cases, the court had to make the finding, first, the person is in fact a member of this organization or has loyalties to that organization. You've heard nothing in his brief and nothing in his argument today that would substantiate that on August 25th, that fact existed. There has been interviews with witnesses, some of whom are admitted militia members, some of whom are admitted far right-wing have right-wing ideology, to a person none of them had ever heard of, talked to, knew of Kyle Rittenhouse prior to that day. None of them. So there is nothing in this record, and there's nothing that Mr. Binger can point to that should satisfy you to even do this analysis, meaning that there has been a showing by a preponderance that he has any of these affiliations, okay? So I don't think they get there. However, if you're going to make the considerations as to whether or not they have provided that evidence to you by a preponderance, and we're going to go to the relevance standard, there is nothing that would indicate that any of these shootings were related to, he describes them as the Proud Boys as a racist hate group. There is nothing in this evidence that would support the idea that any one of these shootings was racially based. I mean, we have to remember the 3 people that were shot are white. The only racial statements that were made that's going to be in evidence in this case is of Mr. Rosenbaum. The first person was screaming the N-word during this. That's it. So to admit evidence that because he's a member or has ties to an organization which he's been unable to prove, that this somehow is a motive for the shootings, when unless they can tie that these shootings are somehow racially related to these 3 people, it doesn't add anything to whether or not it was done in self-defense. It is without debate, Judge. All 3 of these people were chasing Kyle Rittenhouse. All of them. That is not debatable. So for them to say the fact that he has, or they believe he has some tie to this organization, without any information that in fact that's the reason that this happened, it doesn't move the ball further down in terms of making something more or less probable, a consequence of fact. If they can't show that this shooting was related to that and argue that's the reason it wasn't in self-defense, I don't think they move the ball. And I think if you're really going to do the Sullivan analysis, what they're talking about is 4 months after the fact, people in a bar, there's no information that Mr. Rittenhouse knew who they were when the photos were taken. But he's having lunch and they're taking pictures. That is somehow close in similarity to what happened on August 25th. As I mentioned in my motion, my response, August 25th has been described as a war zone in Kenosha. The evidence in this case will be multiple people are armed, whether it's militia members, rioters, threats are being made amongst the groups, there's a curfew, there's police presence. You're going to use that and say, having lunch and taking photos with people with no tie to that organization is somehow moves the ball toward making it more or less probable this was not done in self-defense. I ask that you consider it, as I said, much like courts consider membership in other organizations. There has to be some tie to it before you would allow it to be admitted. I would finally, in this particular case, talk about the unfair prejudice. without a tie to it, without some information that he's part of this group, and without some information that these shootings were motivated by hate or race. It is, the probative value of that is substantially outweighed by its prejudicial value. We are hoping to try this case on the facts, and to admit evidence that bears nothing moving forward on the case, other than to say he has some ties to some hate group, even though there's no proof the shooting was related to a hate group, I think would wildly prejudice the jury as it relates to the facts of the case. So I don't believe they've, certainly as it relates to the Proud Boys, I don't even think you get to this, Judge, unless Mr. Bringer can point to some indication that on that day there's a connection that he can actually put forth in evidence. But otherwise, I believe the evidence is not relevant, should not be admitted. The first one is 2.5 months before. The second one is 4 months after. And I don't think it would assist the jury in any way in this case in making that determination, and I would ask that you deny the motion.
Thank you. Well, I'll tell you, with respect to both of these requests, I think if I admitted either of these, I'd get reversed. That's the bottom line. I think that the first one, the incident involving the sister, this is clear, in my estimation, it's a propensity evidence. It's an opportunity to suggest to the jurors that he's acted in a violent way on other occasions, and therefore he acted in a violent way on this occasion. There's no connection between these two events at all. They're totally dislike each other. One involves a fight involving some kids, including the sister of the accused, and how he reacted in that particular instance, which has nothing to do with what happened in an incident which, and I haven't seen all the videos that you folks have had, or seen witness statements as you have, but it sounds like pretty clearly that at the time that the first incident occurred, and certainly I've seen the videos of the second set of shootings, that in all of the instances there was actually contact between the people leading up to the shooting incidents, and in all of the incidents there was some confrontative behavior, which is certainly subject to multiple interpretations, and I don't want to get into that. That's for the jury. But it's nothing like the incident involving the sister. So this, to me, is clearly propensity evidence. It's exactly the kind of evidence that the rule is designed to prohibit. And as I say, I'm virtually certain that if I admitted this kind of evidence, it would be end up in a reversal if there were a conviction. There's reference. You make reference to having a consistent motive. That kind of thing would be more persuasive if there were similar incidents in which there were demonstrated consistent motive. If the defendant would have gotten up on the top of the high school across the street, and every time a person who appeared to be a member of a disagreeing group walked by, take a shot at him, that kind of behavior would be a consistent motive and would be very definitely admissible, but I don't see any connection here at all. So that request is denied. And while I agree with you that you have the burden of proof, and you can't, and the defense cannot head off your evidence by saying we're going to acknowledge this was a willful shooting, I agree with you there. I also have to be open to the voice of reason in terms of how the case is shaping up, and I don't think there's any doubt about the fact that the defense is clearly conceding the issue, and the law is also clear that when that's the case, the judge has to look at it a little bit differently. Certainly, if they walk in here on day of trial and start claiming that it was the acts of shooting were not willful, then I'll take another look at this evidence, although I certainly don't want to suggest to you that there might be a different ruling, but it would put a different light on it for sure. So that request is denied. The Proud Boys evidence, at this point I don't know, and perhaps you have other information which I don't know about, but I don't know whether there was a prearrangement to meet these people or if there was an awareness of who these people were. I have to tell you, I never heard of the Proud Boys before this case. And you cited a Seattle newspaper, and I'm not going to rely on a newspaper account about what an organization is, whether they're a hate-inspired group or whatever they may be. There's such a spectrum of groups in this country, and it seems to be more every day. But and I don't think it's for the courts, except in the most appropriate circumstances, to be making determinations, and certainly not on the basis of an article in a newspaper in Seattle, about what an organization is. But assuming that these people are a known group that is inclined towards violence, and particularly violence of a particular type, again, directed against particular people, there's still no suggestion in the evidence that's been offered to me that this was anything other than a happenstance occurrence. And even if that isn't true, what the scope of the defendant's understanding was, and obviously it is an unfortunate fact that this case has become a surrogate for a lot of emotional reaction that has nothing to do, or little to do, or nothing to do with the issues in the case. But if this man is accused of these crimes, which could send him to prison for life, and he encounters some people who embrace him and start to, can we take pictures with you, and somehow make him feel better about himself, and he reacts by smiling with them and taking some pictures, for me to let that in as evidence of a motive that existed 4 months earlier, can't see it. Absolutely not. Again, I would expect to be reversed if I did that. I don't know anything about the hand gesture. That's another thing I never heard about before it came up in the context of this case. And I don't know about it, and I sit in the criminal courts all day long, and I deal with a lot of racially charged cases, believe me, and I never heard about this hand gesture, meaning having any, the first time I saw it, or a version of it, was Chef Boyardee on a can of spaghetti.
Your Honor, if I could just briefly supplement. We're not alleging Chef Boyardee is a member of the Proud Boys, by the way. But two things. First of all, this was not a happenstance random meeting. In fact, according to a New Yorker article, which interviewed various... But they interviewed various people involved, and including members of the Rittenhouse family and their supporters. The defendant went to Miami on, I think, January 12th of this year, and was picked up at the airport by the president of the National Proud Boys organization, who took him out to lunch. That was intentional. So this is consistent. This is a pattern. This is not a random meeting at Pudgy's Bar in Racine.
When was the event?
This was January 12th. So this was 9 days or 8 days after the incident at Pudgy's Bar in Racine. The defendant's in Miami, picked up at the airport by the head of the National Proud Boys organization. So I submit to you, the question the defense asks is, what's the proof that he's affiliated with this organization? This is the proof. He goes out after court, drives up to Racine and meets them at a bar, goes to Miami, is picked up at the airport, and has lunch with the national head of that. So this is the evidence of the affiliation.
What does that mean about August 25th of last year?
And the jury can make a decision on that, Your Honor. I believe that it is consistent with the Proud Boys' mantra, their philosophy of going to these types of protests armed with the intent of causing violence. And I think we will be prepared to introduce testimony from someone who is affiliated with the Proud Boys, and will tell the jury about their philosophy. We'll tell the jury what sort of violent activities they do at these incidents. So again, I understand the court doesn't want to rely on a Seattle newspaper article. We will have a witness who will tell the jury exactly what the Proud Boys is about, exactly what they try and do, exactly what their philosophy is. We'll identify the people in these meetings. Okay, so I understand the court may believe that because of the prejudicial nature of this, we're not going to introduce the evidence, but I want to button down those two issues. This was not a random chance meeting at Pudgy's pub because of the incident in Miami, and second of all, we will introduce evidence about the Proud Boys, far more than a newspaper article. So those issues, we can surmount those obstacles to the court's ruling if that's what the court is concerned about.
All right, let's assume you're bringing in the evidence about the Proud Boys being in Kenosha on the day in question, and that they're here for their purposes. Is there any suggestion that they were connected in any way with the accused?
On the date of August 25th, I will acknowledge that I'm not going to be able to prove that that was a coordinated thing between the defendant and the Proud Boys that night. However, I believe there's a strong inference based on the fact that after court in January, he goes out to Pudgy's, goes down to Miami later that month, and meets with not only the head of the Wisconsin Proud Boys, but the head of the national Proud Boys. I think there's an inference to be drawn from that. Now, the jury can be instructed what weight to give it, but the defendant's actions of coming into our community illegally after curfew with a gun at the time of a protest is entirely consistent with what the Proud Boys make it their job to do. And then he meets with the leaders afterwards. To me, I think there's a reasonable inference that these are consistent motives all along.
And you've been in here enough, Mr. Krause has been in here enough to know that we get these pre-sentences where the defendant is accused of any number of things, and there's a section in there about gang membership. And I have stated probably 100 times, probably more than that I breeze right past that because I'm not interested in these accusations about group responsibility unless it's directly connected that the defendant is active in the criminal enterprises of the organization, or, there's kids in neighborhoods right here in Kenosha who join gangs because they're afraid not to. Pope Benedict was a member of the Nazi youth because he had to be. This type of evidence is very dangerous. You make some points that might be legitimate. I certainly would keep the door open if you can show that there's any connection between the defendant on the day in question and this organization. But as I said before, if this organization embraces the defendant after the fact because he's lionized because of his behavior, that is not something that the jury can make anything out of that would be lawful. So, as I say, I'll keep the door open a small amount if you've got some evidence to suggest that there was some prior knowledge or awareness, but otherwise, I think the evidence would be poisoned and would not be allowed. All right, now the next one is the defendant's first motion in limine, and that, well, there is a series of statements in there. Let's see. He's asking that the state be prohibited from the Pudgy's incident. That's in point 3, and I've already discussed that. The evidence that where the source of the funds with which Mr. Rittenhouse purchased the firearm is that he wants to prevent that from being offered. Is that any reason you want to offer that evidence?
Absolutely, Your Honor. The defendant is charged with illegally possessing a firearm. The circumstances under which he possessed that firearm are directly relevant to that charge. So how he obtained it, how he purchased it, the circumstances under which he purchased it, how he paid for it, etc., all of that is relevant. I believe that there will be testimony with regard to this. I don't think there's any dispute that the defendant turned around and used his stimulus check very shortly thereafter to go up to Ladysmith, Wisconsin with his good friend Dominic Black and used It's relevant, Your Honor, because Mr. Black was working essentially as a straw purchaser here, Your Honor.
That's a separate issue. What he's asking and not be allowed is evidence about the fact that he used the stimulus money to buy the gun. Where's the probative value of that?
Well, Your Honor, I think it paints the picture for the jury of how this transaction occurred. How does Mr. Rittenhouse come into this money? It's a lot of money. We're not talking about $50 here. We're talking about $800 or thereabouts. So it's a large sum of money. Mr.
Actually,
Rittenhouse,
you're providing the explanation. I would think that you'd want to offer that. Where did he get this money? I don't understand.
We can leave the question open for the jury, Your Honor, and we can let them try and speculate if they want to. But since we already know the answer, why not tell them the truth?
Why tell them anything? I mean, he had money. He apparently had a job as a lifeguard or something. I read.
I don't know that he had that job at that particular time, Your Honor.
I don't want to get into it.
Yeah. I mean, the defense is going to talk about his work as a lifeguard. We've already heard reference to him, working in our community, although he worked in Pleasant Prairie. But
what is the relevance of the stimulus money being used for that as opposed to being used for drugs or for new musical instrument or a boombox, or is it? I don't know.
If we want to cut off reference to that
term, boombox, I don't know.
If we want to cut off reference to that, Your Honor, then why don't we just cut off reference to the defendant working in Pleasant Prairie as a lifeguard too?
You haven't given me a reason.
Well, I think it's the same issue. I think it's the same. It's two sides of the same coin, Your Honor.
Yeah, I would tell you that I don't think it's a big deal, but I do think the defense is correct. That it doesn't sound to have much relevance. I also don't. You're suggesting that the reason he's trying to do it is to denigrate the defendant for not using the stimulus money for a more altruistic purpose. I would imagine that some percentage of the American people who got money used it for altruistic purposes, but I would bet most didn't, including some who probably spent it on illegal drugs.
I just don't see how it goes to any element that's in dispute here. I mean, it's just, I think it is to denigrate him, to try and paint him bad, and that's why they put it in the Washington Post article. I believe that's where it was got, or the New York
Post article. I did, by the way, read that New Yorker magazine article that you mentioned, but I didn't read.
I don't think it's an issue of denigrating or making him look positive. The stimulus money was intended to stimulate our economy. It was designed to be spent at various locations, whether you go out and you buy groceries or you spend it on your rent or you buy a gun. It certainly benefited the Ace Hardware in Ladysmith to sell that gun. There's nothing wrong with that. Gun ownership is legal in our country. Dominic Black purchased the gun. He's legally able to do that. Of course, the defendant isn't, but there's no implication here by the fact that it's stimulus money used to purchase a gun. There's no automatic implication, positive or negative, on that. It's exactly what the stimulus money was intended to do, was to be used to stimulate our economy by supporting businesses.
Yeah, I think it's going to elongate the trial. So to me, it's, I'm not going to give you a definitive ruling now because it's not, in my estimation, it's not that objectionable, but it's also not that probative. And I tell you what, we're not going to spend as much time at the trial as we are today talking about this, because we want to move this case along. So if he asks and you object, you're going to get a one-word response as to whether I decide at that given moment in time whether it's, and that may have something to do with the pace at which we're moving. So I just don't want to get bogged down. The item number 3B, that's Pudgy's again.
Your Honor, I think 1 and 3 in the motion in limine are covered by your ruling on the other act motion, so I don't know that we need to spend any more time on it.
Judge, I think it's everything then. I think this was filed before the state filed their other acts motion.
All right.
So it was kind of done preemptively.
So we're all done with this?
We are.
Yep.
Motion to admit evidence. That is evidence of whether, because Joseph Rosenbaum had been convicted of child sex offense and went to prison for it, I guess, three different times. You can start talking with an extreme bias towards denying your request.
Understood, Your Honor.
Okay.
Your Honor, his status as a felony offender is relevant in this case because based upon the facts of that evening and his conduct. When Mr. Rosenbaum was on the scene on the 25th, he made threats to numerous people, including my client and Mr. Balch, where he specifically said, if I get you alone, I'm going to kill you. And that happened earlier in the evening. It's reported. I received that in discovery from the government. It's from an FBI agent who interviewed Mr. Balch. Mr. Rosenbaum made other threats about not being afraid to go back to jail. He stated, I just got out that day, which was overheard by my client. And ultimately what ends up happening, and it's on the video, my client is walking down the street, Sheridan Road, towards what I would refer to as car source 3, where the first shooting occurs. As he's walking down that road, Mr. Rosenbaum becomes aware of Kyle. He has been called and asked to go there to potentially put out fires that people are starting at that location. He asks for...
You're talking of
my client.
Accused. Okay, go ahead.
He asks for a fire extinguisher from the gas station at the corner of 60th and Sheridan Road. Somebody provides him a fire extinguisher. He takes off in the direction of 63rd and Sheridan Road, car source number 3. As he's going to that location, Mr. Rosenbaum and Mr. Zeminski are seen on video behind him. And in front of him. My client starts off behind him, goes past them. As my client passes Mr. Rosenbaum has his face covered with his shirt in a ninja type mask, not a COVID mask. It has over the top of his head and a slit for his eyes, hiding his identity. As my client goes by him, there's statements of get him, kill him, things like that. Whatever is said, it's in dispute, but there's something clearly said. As my client is aware that he is being chased, he's also being followed by a reporter by the name of Richard McGinnis. As he's being chased, McGinnis follows him. My client runs into the lot of car source 3. Right before he enters the lot, he's being chased. He drops the fire extinguisher so that he can get away faster, I would submit. As he gets into the middle of the car source 3 lot, Mr. Rosenbaum continues to follow, chasing him. He throws something at him, which has now been determined to be a metallic type bag. You see it clearly in the video. Mr. Rosenbaum fires it at my client. There's evidence that there was something in that bag that was removed before it's recovered by police, also from a statement from, I believe it's Mr. Balch. My client turns around, addresses Mr. Rosenbaum, still being followed by Rosenbaum chased and Richard McGinnis off to the side. Turns around when Mr. Rosenbaum does not stop, even though he's pointed a firearm in his direction, and begins running away further, and he's looking over his shoulder back at Mr. Rosenbaum, who continues to advance. Richard McGinnis states that Mr. Rosenbaum continues to run at Kyle, even though Kyle is now addressing him and pointing a firearm in his direction. Mr. McGinnis states that he lets out, as he describes it, a blood-curdling scream yelling the F word.
He being?
Mr. Rosenbaum.
Go ahead.
My client, as he's jumping towards him, fires the 4 shots, which take less than 1 second, hitting Mr. Rosenbaum. Your Honor, Mr. Rosenbaum had the will, he had the intent, and he had stated what his motive was, to take somebody who he believed as a threat, who had put out fires that he had been starting, had been stopping them from burning down buildings, and now was his chance. Mr. Rosenbaum, because of his status as a convicted felon, is unable to lawfully possess a firearm, could not purchase a firearm. He saw this as the opportunity to possess a firearm and take care of what he believed was a threat or a problem to the rioters, not demonstrators, rioters, which Mr. Rosenbaum was. There's numerous photos earlier of Mr. Rosenbaum wearing a shirt in a proper fashion over his body. not using it as a mask. In the state of Wisconsin, hiding your identity to commit a crime is in itself a crime. He was doing that. Your Honor, the case that I've cited in the brief, State v. Ingram 204 with 2nd 177, and it's also cited in the annotations for the witty cautionary instruction. And I know the court knows that it's your case. It's the fleeing and the looting, and the state sought to put in the fact that he was convicted. In this case, it is our argument that he was trying to take the gun, one, because it was readily available, two, he could not legally purchase one. Many of the individuals that evening on both sides of this were heavily armed. There's Black Lives Matter individuals with guns. There's people who are protecting property with guns. There's militia members parading around. It's our position that Mr. Rosenbaum could not legally possess a gun, but that wasn't going to stop or deter him. And, you know, I read the newspapers, I read the stuff, and everybody's, oh, he just wants to put that in to sully the victim. One, it hasn't been determined.
To sully the victim? Okay, go ahead.
One, it hasn't been determined whether he's a victim or whether this was a justified homicide on the part of my client. Secondly, under Old Chief versus U.S. 204, United States 177, there could be stipulations that could be entered into. In this case, it doesn't have to be that he's a convicted pedophile. It can be that he was a convicted felon, which serves a purpose. He was stealing a firearm while masked, attempting to, which is a felony in the state of Wisconsin. Theft of a firearm, masked, felon in possession of a firearm are just a list, not to mention attempted battery, things like that, that he was attempting to do that evening to my client before he was shot. It's highly probative. It explains why Mr. Rosenbaum possibly didn't bring his own gun, why he was seeking to get the gun from my client. And that isn't my client's words. My client would testify to that, but it's an independent witness who the government has listed as a complaining witness, Richard McGinnis, who says he was going for Kyle's gun. And that's in interviews to law enforcement, and that's in interviews to my investigator.
Did you say, when you began, that there's a witness who reported hearing Mr. Rosenbaum say he just got out of jail that day to the accused?
Yes. He said he was announcing it to the people at Car Source 2 where my client was in the property. And it wasn't jail. He had gotten out of a mental institution, what is the evidence, I think.
Well, what institution he was in was not important. What the what the decedent allegedly said is the important thing. He allegedly said what?
He said, words to the effect, I just got out of jail today, I'm not afraid to go back. And
is that in the discovery, I assume?
I don't remember those words. I know he had gotten out of I think it was a commitment that day, not jail, but I don't recall seeing those words.
Go ahead, I interrupted you.
Your Honor, that's the argument. He said it. It's in the discovery, which I was provided by the state. It's reported by numerous individuals, and you know, there's that incident. There's where he's yelling to people, "Just shoot me, N-word." He was not a demonstrator. He was somebody who came to Kenosha, whether he lived here or he didn't, came to the downtown area to wreak havoc on this city. And our position is he ended up attacking our client because our client was alone, and our client ran from him as far as he could. And in the drone footage, you see him run up against a wall of cars. He stopped at that location, and he can't go any further. On the other side of the cars, from the drone footage, you see the demonstrators bashing in the car windows, and he didn't want to run through that. He turns around, he addresses Mr. Rosenbaum. After Mr. Rosenbaum's buddy, Mr. Zeminski's already fired the first shot within seconds of Kyle firing.
Mr. Finger.
Judge, there are a lot of people out there commenting on this case that are happy that Kyle Rittenhouse killed a pedophile. And that's the danger here. We don't want the jury to make a determination that somehow this was justified because it got one child molester off the streets. That is not what was going on here. I want to clarify that Kyle Rittenhouse knew none of this at the time of this incident, had no idea that Joseph Rosenbaum had ever been convicted of felon, had no idea he was a sex offender or anything like that. So this doesn't go to Kyle Rittenhouse's state of mind, and that's important for self-defense. This is not a subjective issue. This is not a reasonable issue. It does not go to self-defense at all because there's no evidence Kyle Rittenhouse knew anything about Joseph Rosenbaum's history that night. They had never crossed paths before that night. They'd never met.
And I agree with you on all of those points that you're making. I guess I'm struggling with, and as you recall, I started by saying that I had extreme bias against the defense position, but I'm struggling now a little bit because I'm hearing about this statement allegedly made by Mr. Rosenbaum about having just gotten out that day and not afraid to go back. If that is in fact testimony that's going to be offered at the trial, it does put a different light on it. Not about whether he's. I would be surprised if I would admit evidence that he was a sex offender, or that he had the number of times he had gone to prison, or the revocations. However, if indeed there's evidence produced that he made the statement about just having gotten out that day, that certainly does put a little bit of a different light about it. So you don't have to convince me that about what was in the mind of the accused, other than the statement allegedly made that he had just gotten out that day. And so why don't you argue on that point?
Sure, Your Honor. With regard to the motive that Joseph Rosenbaum had that evening when he confronted the defendant, because that's where this really goes to. The defense wants to argue that his motivation in confronting the defendant was, among many other things, which counsel's just detailed, a desire to obtain the defendant's gun because Mr. Rosenbaum couldn't get the gun any legal way. That is really what this is. He's a felon, so he can't go to Dunham's or Gander Mountain and buy a gun. He's got to steal it. That's the only reason why this fact of his felony conviction could possibly come in at trial, is to show that motive. So, how plausible is that motive? First of all, we have no evidence that Joseph Rosenbaum wanted a gun that night. None whatsoever. No one is going to testify that he ever tried to get a gun since his last felony conviction, that he ever said he wanted a gun that night, that he ever said anything about wanting to get armed that night. There is nothing in this record as to him saying anything about his motivations with regard to a gun. Second of all, counsel's acknowledged everybody had guns that night. In fact, earlier in this hearing, counsel referenced a racist statement that Mr. Rosenbaum said. That is on video. Everybody's seen it here in the court. And it's clear Mr. Rosenbaum is walking up to individuals that are similarly armed to Mr. Rittenhouse, that are openly carrying AR-15 style assault rifles slung around their shoulders. He gets in their face and he is challenging them. This happens on the videos. Now, does Mr. Rosenbaum at any point reach for anyone's gun in that situation? No. Does he try and take it away from anyone? Does he say, let me have that gun? Does he say anything about a gun? No. So I posit, Your Honor, that if Mr. Rosenbaum showed up randomly in Kenosha that night, after having been released, and decided, this is the night of all nights, I need to go get myself a gun because I can't buy it at the store. If he really wanted to steal it, he had the entire evening to steal it from countless people. But he wasn't chasing after Mr. Rittenhouse because he wanted to steal Mr. Rittenhouse's gun. Counsel's already detailed numerous allegations or parts of the story that the defense will try and introduce evidence on that suggests that there were other reasons why Mr. Rosenbaum may or may not have been chasing Mr. Rittenhouse. And by the way, I don't concede the narrative that counsel laid out about the facts here because I think there's more to the story, which we'll get at trial. But at any rate, if you listen to counsel's argument, the allegation is that Mr. Rosenbaum was starting fires. He was trying to destroy property. The defendant was grabbing a fire extinguisher, trying to stop Mr. Rosenbaum. They had multiple interactions, at least one at the car source on 59th, and then maybe later on as they're traveling down Sheridan towards the 63rd Street car source. At any rate, those are all potential explanations why Mr. Rosenbaum may have had a motive to do what he did that night. And they are far more relevant in time, plausible, and consistent with the evidence than this obscure notion, this implausible and irrational notion, this unreasonable notion that Mr. Rosenbaum decided this was the night that I need to go get myself a gun illegally on the street, and that's the person I'm going to take it from. I mean, Mr. Rosenbaum, to say that the best way for him to go get a gun that night is to approach an openly armed individual carrying an assault rifle slung around his shoulder and take it from him by force, it strains credibility, Your Honor. Now, in their motion, the defense has suggested that there's some evidence Mr. Rosenbaum was reaching for Mr. Rittenhouse's gun. Now, they didn't mention that here in the hearing, but it's in their motion. Well, let's talk about the circumstances of that interaction. Yes, it is on video that at some point Mr. Rosenbaum is running through the 63rd Street car source, chasing after Mr. Rittenhouse. He throws a plastic bag. It's not a metallic bag. It's a plastic bag towards Mr. Rittenhouse, which lands harmlessly 10 feet behind Mr. Rittenhouse as they're running.
I've read that over and over again about the plastic bag being thrown at somebody. Now, if I throw a plastic bag at you, I guarantee it's not going to hit you. And that would be true if you're standing 2 feet ahead of me. So I guess I'm interested in what the images show about the course of the plastic bag. I mean, did it just project a foot and then drop to the ground? Or did it act like a missile in the direction of the accused?
There was something inside the plastic bag.
There was something inside of it.
We've never been able to determine exactly what it was because it was not recovered in evidence. This was a scene where, obviously, because of all of the chaos and situation...
The point is that it's shown on video.
It flies into the air.
It's not just a plastic bag, which is what the complaint says, a plastic bag.
Sure. It flies into the air. It lands about 10 feet behind the defendant as the defendant is running away. I don't think anyone can reasonably argue that it was a risk to cause bodily harm at any level to the defendant. I suspect Mr. Rosenbaum threw it out of frustration or anger, but it's not a reasonable threat to the defendant's safety.
My question has been answered.
Okay. So then what happens is these individuals run between some parked cars, and there's an allegation in the defense motion that Mr. Rosenbaum is reaching towards the defendant's gun, may have come into contact with the gun, although there's no physical evidence to support that. But at any rate, why is Mr. Rosenbaum allegedly doing that? We don't know. We don't have any statements from him. We have speculation from witnesses. We can speculate by watching the video, but that is all that is pure speculation. Now, I submit that in that circumstance, the most reasonable explanation why Mr. Rosenbaum may have been doing that is the same thing any of us would do if someone pulled a gun on us, is probably try and defend ourselves by pushing the gun away or knocking it away or anything like that. But the notion that in that moment he thought to himself, I'm a felon, I can't go to the store and buy a gun, so I'm going to take it away from this random individual on the street, is utterly preposterous, Your Honor. So I don't think there's any plausibility here. I don't think there's any evidence as to the Sullivan factors of motive, intent, knowledge, anything along those lines here, because we simply don't know. And Mr. Rosenbaum, obviously, is not in a position to answer any of these questions because he's deceased. So we're talking about the motives of someone who can't defend themselves, can't respond to any of this, and that is completely improper.
Your Honor, just briefly in response to some of the more interesting points Mr. Binger made. One, the evidence is timely. It's part of what happened that evening. Two, Mr. Binger talks about there were other incidences where he was with individuals going at them who were armed with AR-15s. The very distinctive thing between those incidents at the gas station on 60th and Sheridan Road and the situation between my client and Mr. Rosenbaum are, my client was alone. It was not well lit. Gas station where Mr. Rosenbaum is going nuts, yelling, shoot me in, repeatedly, he has to be held back from those individuals with guns. And there are numerous individuals. It's no individual standing alone. He's going at them. the threat regarding I just got out of jail and I'm not afraid to go back was earlier in the evening at Car Source 2. The bag incident, the state can talk about it not being or meaning anything. It was a metallic bag. You can clearly see it fly through the air, lit up from the lights that were in that area. And the client will testify that he had seen Mr. Rosenbaum, this is on video, right in front of Car Source number 2, walking down the road with a huge chain that had been taken off a trailer that Mr. Rosenbaum and other individuals had threatened. So he knows he has something metallic. And he talks about Mr. Rosenbaum defending himself and it being rational. Your Honor, it's not rational to chase somebody unarmed with a firearm. But he chose to do that. And he lives or dies with the consequences. In this case, he died with the consequences, trying to take a firearm from an armed individual. And we can say, the state can say it's speculation, and I can say it's not speculation. He wanted a firearm. That's why he was masked, and that's why he attacked someone who was by themselves, who was on the other side.
Well, I certainly you're welcome to pursue the evidence and attempt to prove that the decedent was attempting to take the gun from the accused. But I think that he was there are a universe of motivations that Mr. Rosenbaum could have had, and to invite the jury to speculate that it was because he couldn't legally acquire one, that's too much for me. So I'm gonna grant the. I guess it comes in here as a request on your part to admit that evidence, and I'm going to deny that request. Notice of intent to introduce. Oh, this is the testimony of John R. Black. By the way, the clerk told me that there were some materials received today about expert witnesses that I have not seen. They were not filed until either this morning or last night, yesterday afternoon, and I haven't seen them, and I hope they're not something that you expected me to talk about today, because I've not even seen them. But I do have the discussion regarding John Black, and I will tell you before I hear what you have to say.
Your Honor, before we go any further, can we just take like a 5-minute break?
Your wish is my command.
Kind of works.
All right, let's start again at 25 after.